So good afternoon, everyone. Welcome to G-IPTech lecture. So I have to start with a message from John Carlo. Due to unforeseen circumstances, he's not able to attend this event. So he sends his apology to our speaker and also to all the participants for his absence. So in his absence, I will chair the session. And let me introduce to our distinguished speaker. So we have Professor Laurent MANDERIEUX. He's a professor of IP law in the University of Bocconi in Milan. So he's well-known IP scholars, European IP scholars, and he has worked in academia, and also he brings rich international advisory experience. He has worked with WIPO, UNCTAD, and he has commissioned several reports. So I don't want to further take time to introduce him. I think his talk is extremely important and timely. So he will be delivering a lecture on upside down AI-led revolution of IP. Floor is yours, Professor. And once the lecture will be around 40 minutes and we'll have Q&A.
Excellent. Thank you very much. Let me try to go back to the slide. So thank you very much for the invitation. It's for me a pleasure and honor to be with you today for this presentation that I would wish to be as interactive as possible, because it is done for you so that we can share reflections. We should have time to reply to questions and to make you fully protagonists of it so that we construct together. The purpose of my presentation is dedicated to Upside Down, the artificial intelligence-led revolution of IP and its wider implications. I base myself for this on my research at Bocconi University. We are quite dynamic on IP. We have 23 IP courses and we have many research lines. We are very much committed to studying how IP can be of help to society, in particular from the legal and economic point of view. So the big objective of today's presentation more in detail is to study the AI revolution and how its many definitions provoke, in any case, an IP revolution. This revolution is led by Eastern Asia and North America, but actually mostly by Eastern Asia. And it creates an open debate, or many open debates, on where this revolution brings us as legal scholars, brings us as mankind, of course. And this is what I would wish, these are the points I would wish to explore and discuss with all of you during this early afternoon session. So, the AI revolution and how we are connected to it from the legal point of view. First of all, we are in 2025. If we were in 2024, everybody was talking for the first time of the year of AI. AI is on each and every discussion in academia, in business circles, in society. But AI has not all of a sudden appeared and blossomed. AI is a constant phenomenon. The issue, the word appears, is a coined word that was created at the Dartmouth conference in 1957 by some scientists. This is basically the possibility that machines, that robots do what we are doing, replace us, question mark, for the good, for the bad, question mark. The issue is at stake for practically the last 70 years. So this is not at all a new topic. The only thing is that this is a topic that has had ups and downs. In the late 1950s, in the early 1960s, there was a strong government funding, an enthusiasm in the population with robots and the culture of robots. From movies to discussions in society, robots would replace us, would alleviate us from painful tasks, would perhaps threaten us and govern us. Don't you think this is exactly what you read yesterday in the newspapers? Okay. So this was already the main topic and the main worry. The conquest to the moon by the US and the rivalry with USSR was the big topic. This is still in the picture, but this crystallized basically this issue on mankind versus robot, the eruption of robots in our life, for the good, for the bad, question mark. Yet there were two big eclipses in the 1970s and again in the late 1980s in this growth of artificial intelligence and therefore use of AI or interest of AI for law, simply due to limitation in computing machines. There were the inability of computers to take care to process the data on two different waves blocked the possibility of growth of AI. And AI is back in the early 2000s with more powerful computing machines by IBM, by Apple, and also more increased data. Companies that were perfectly unknown to us before the early 2000s appear. Google under its current name or under the previous one, Google, but also other types of companies, the GAFA, were completely not existing. Just as as of 2023, 2024, new companies appear, such as NVIDIA, that were perfectly unknown 3 years ago. Okay, so fundamentally, this is a continuity. So last year, every AI was on all conversation. The year before, we were all talking about the metaverse, and the year before about blockchain, and the year before about 3D printing. But actually, this is the same thing. This is the eruption of technology in the further eruption of technology of artificial intelligence in our life. So nothing new, yet everything totally new. There are many definitions of AI, and there has been a constant evolution of the AI definition over time. There is no single accepted definition. This is why all of you, depending on your background, on your generation, may see individually a different thing on what AI is. Taken from WIPO, from the World Intellectual Property Organization analysis, there are several levels of AI that are AI. It may be super intelligence, something that goes beyond the human being, okay? Or that is equal to the human being. Yesterday, some of you read that a new Chinese robot called Manus is supposed to be able to be better at programming and performing tasks than any of us, and then all of us put together in this classroom, okay? So every day there is still this eruption of what could be the fifth phase, not even the fourth one, of artificial intelligence. Is it really the right one, the new one? Is it one among new ones? Question mark. That may be super intelligence. AI may mean less. It may mean systems that think like humans, that act like humans, that think rationally, that act rationally. So like humans, but not as humans. Superintelligence is something that is as human or beyond humans. AI, up to now, may be in the phase of thinking like human, acting like human, thinking rationally, acting rationally. Yet AI is not at the phase of acting irrationally. And this is something that we need to remember, especially for us as lawyers. Why? In particular, because current AI modes, models, applications have a lot of difficulty in forgetting and forgiving. And we human beings, we need to forget things. In the current human intelligence, for our construction, for our destruction, for our destructive construction, we need also to forget, to be able to forget. And the way we forget does not obey to systematic models. Okay, psychology, psychiatry, medicine has passes to study the way to forget. But there is no single method of forgetting. And AI is a cognitive intelligence up to now, and not an intelligence that fully understands this element. Well, AI may be less. They may simply mean intelligent agents. They may only mean machine learning, something very simple. So there are so many levels of AI. Whatever level we consider, these levels in any case provoke an IP revolution, a revolution for how IP is to be considered. For the WIPO Technology Trends report, we consider AI in its simpler, linear version. It is viewed as learning systems which become better through training at a task. So that's really machine learning, typically performed by humans and with limited or no human intervention. And even with this very, very limited definition, this encompasses many AI techniques and functional applications. This is a narrow AI definition, opposed to general intelligence, artificial general intelligence, and to superintelligence. And yet, this provokes a kind of earthquake. Well, we consider under the WIPO Technology Trends report the three main aspects: techniques used in AI, such as machine learning, functional applications, and application fields. So these are initially what we shall consider as a basis, and then we will go further to new definitions of AI. Still, this narrow definition of AI creates the need to revisit the IP concepts. Intellectual property adapted to technical revolutions for over 150 years, including to the internet. But it is said, it is considered by most, practically all IP scholars, that it hardly adapts to AI. So intellectual property was, modern intellectual property law was created by, or was founded by the Paris and Berne Conventions of 1883, 1886, on industrial property and on copyright respectively, and they could adjust to radio broadcasting, to TV broadcasting, to satellite broadcasting, through minor amendments of the existing treaties. They could adjust to internet, which one scholar has depicted as the largest photocopying machine of the world. Why? Because they did not challenge the principles of national treatment and the principles of territoriality. Internet does so to an extent, but still there is a national root to each right. So this was possible. With AI, we face another problem, and we face actually 4 problems that we scholars have a lot of hardship to sort out. And the objective is in this presentation today is to discuss with us these problems, but not to leave this room with a winning ticket and a solution. There are none. So there are 4 key problems. Well, first of all, the AI output issues. This brings an issue of this challenge, AI, artificial intelligence, brings an issue on inventorship and connects to it on authorship. Who invents, the human being or the machine? Of originality and of non-obviousness. If the machine is so efficient and fast, it can repeat so many concepts in an applied way that it occupies all the aspects of originality and non-obviousness and of novelty. There are also AI input issues. Can AI become an inventor or an author on its own? I wouldn't say on his or her own. So, and if so, what about the liability of AI for its creations? But there, this creates a lot of worries among IP scholars. But imagine we were in this very room before the foundation of Queen's University in the mid-17th century in this part of the world. And if we were considering the concept of company, of an incorporated company with no human beings being the company, this seemed to the human beings of that time, to many human beings, as a challenging, if not a crazy project or crazy legal construction. Can a machine have rights? I want to be clear. I am not advocating necessarily that they should have rights, that a machine should have rights. But without any doubt, there is this challenge that we are not used to. Of course, this creates, if the AI becomes an inventor and author, can it be liable for these creations? I brought the issue of the incorporated company because the incorporated company can be liable. Can a machine become liable? This also brings the issue of IP of those who fed the AI inventor. So this is much connected to AI as platforms for collective works, collective authorship of the topic of the data mill. In the Authors Guild case in the US against some GAFA companies, in the case that was brought yesterday to court in France by the French Authors Guilds against Alphabet and Meta and others, we are exactly in this situation. What are the rights of those who are gathered in platforms for collective works? Now, last but not the least, AI is a support for IP promotion. Patents that are granted by the 5 largest offices of the world are largely based on research, which is made thanks to AI, on novelty, on non-obviousness. And same thing for trademarks, it's even easier. And same thing for industrial designs. Fighting infringements by or thanks to machines may become easier, not talking of judges' decisions granted thanks to machines, if not one day by machines. So clearly enough, the IP concepts are largely revisited, above all, authorship, inventorship, with all the possible consequences that it has on us lawyers, on us human beings. these are important legal considerations. Now, we are Europeans in the European continent, whether in the EU or outside of the EU. We are Europeans, and we are sometimes defined in the other parts of the world as being big thinkers rather than big makers nowadays. And unfortunately, statistics confirm this. The revolution of AI is led, unfortunately for Europeans, but fortunately for some others. So the statistics show that the revolution is led by Eastern Asia and North America. And I would wish to draw your attention on statistics of 2016, oldish ones, and then moving to more recent ones of 2023, the latest we have. In 2016, these statistics were clearly scary for Europeans. In AI, in patents, that is the key way to analyze research and innovation, there is a complete dominance of Chinese universities. 17 out of top 20 academic patent applications are from China, were and still are from China. The remaining 3 are from the Republic of Korea. The rest of the university world was out and is still out. Out of the 500 top patent applicants, over 100 were Chinese public research institutions. US and the Republic of Korea have around 20 each. Japan and Europe, 4 each. So clearly enough, we are talking a lot, analyzing a lot from a legal point of view, but others do. Now, why do others do? Others do simply because they invest in research. Their governments spend far more in scientific research than our governments. They fuel businesses to spend more on scientific research. And this is clearly in Asia. If we move to 2023, we find somehow exactly the same situation. The revolution is still led by Asia and North America. By the way, I forgot to mention one thing concerning North America. For those of you who are more deeply involved in analyzing patents by patent law of all our countries in the world, there is the patent which belongs to a company, to a university, sometimes to an individual. And if belonging to a company or a university, there is always the name of the individual inventor. If you look at the names of individual inventors of most patents in the US, and even sometimes in Europe, the names are names from China. So basically, there is a very large Chinese inventors who went to US universities, Chinese researchers, patent from there, as new Americans or as Chinese. So basically, the factory of the world, but not only the factory of the world, the smoking factory of the world, the intellectual factory of AI is somewhere in the eastern part of the Asian continent. If we look at the growth of AI patents compared to other sectors, tech sectors, that means high tech sectors, we have from in the last 5 years plus 718%, plus 100% on generative AI patents, and still scary statistics for Europeans. In 2023, on generative AI, you have 54,000 generative AI patents and 73 general ones. sorry, 54,000 generative AI patents and 73 generative AI publications. So 21% of all generative AI patents date in 2023 alone. So all this is brand new. Generative AI just erupts as of last year, basically, which is exactly what I depicted earlier. The trend of development of the AI, now the generative AI phase. But still, it is only 6% of all AI patents. There is a complete dominance of China. Nothing has changed. More than 70% of total patents on generative AI. 13 out of top 20 patent applicants are from China. This time there are companies, not universities, which means that there is even more maturity in the AI business than in 2016. 10 companies and 3 universities. The remaining 4 are US, 2 are Japanese, and 1 is Korean. So the US enters a bit into the picture as a minor player, and Eastern Asian players remain dominant. Still, there are interesting developments if we look at statistics. China has 38,000, Chinese applicants, 38,000. US, 6,000. So out of 53,000, 38 are Chinese. 6,000 are Korean, US. 4,000 are Korean. 3,500 are Japanese. 100, sorry, I made an error with a 0. 1,500 are Indian. And this is interesting because India was out of the picture and comes in the picture with the fastest growing rate. Still a very, very small rate compared to China. UK 700 and Germany 700. So yes, not so bad for UK or Germany, but 700 out of 38,000 for China, which is perfectly insignificant. Okay. So France has 600. So basically, the European figures are, even if all put together, perfectly non-interesting, which is an issue. So we are discussing mostly in this part of the world a topic which is not ours. It's done elsewhere. The technology is done elsewhere. 70%, if not 80%. So basic, and if done in the West, it is mostly done in any case by Asian engineers. So, well, I'm here to talk about legal consequences, and we should study for us lawyers the recent dominance of patents in AI and the fact that this revolution is favorable to patent protection rather than to copyright protection. Why is it favorable to patents? Because patents are more easily more easily be enforced than copyrights, and that's why patents interest more business and research centers. They can be more easily monetized, especially in case of need for enforcement. And this is why there is a quick turn into patents rather than scientific publications. You start with scientific publications. We IP lawyers know that you should always patent before publishing. This is fine, as long as you have an invention that can be patentable. When you are at an early stage of your scientific research, you cannot patent it because you cannot have sufficient application for it. So in any case, in the first years of a technology, this is an abstract research issue, and you can't patent. At the moment, the publication ratio diminishes and the patent ratio increases. It means that the techniques are at maturity and AI is back to maturity. So that's why after 2013, you have this strong inversion and patents start to explode. Numbers start to explode exponentially in patents. Publications continue to develop steadily, but nothing too special. So publications blossom 10 years before patents, and then now patents blossom a lot. So we were 8 versus 1 in 2010, 3 versus 1 in 2016, which means that the AI market is now at maturity. I don't need to give examples because from this university to going outside anywhere, you are surrounded by AI applications all the time. So it's clear for all of us that it is at maturity. How to categorize now generative AI? Generative AI is the fashionable subject of the year because this is the current stage of development of AI. So this includes, in the statistics that I showed you earlier, models, modes, and applications. Of course, in these recent sad months and weeks, we are focusing a lot on the very, very last dot of this slide. But there is a lot in each and every aspect of Gen AI, which is pervasive to all our elements of our life. And this is why so many people, so many students, not of the law faculty, but of other faculties, at the end, create new generative AI models, modes, applications. And this is why in this faculty, lawyers need to analyze what they create. Now, there are wider applications of this change for revised IP standards. First of all, on copyright and AI. Imposing human authorship as a prerequisite to copyright may threaten protection and production of work that can alternatively be produced by AI and humans. If any of you wants, for the ladies in this room, want to marry, or for the men in this room want to marry and have any suit for the wedding, you would go to a fashion designer and he or she, not it for the time being, will in any case use it, who would in any case design the model from what exists in AI templates. This productivity by AI is superior than the one of humans. And why should we deprive me, of it? So an old conception of copyright may deprive mankind of progress. This is what a certain president of a state on the other side of the Atlantic is saying these days. There is some truth in it. On the opposite, AI new generations that are based on training of machines can be done with marginal costs, and it can explore all possible models that exist. And therefore, there is no space for any other creativity, question mark. And therefore, AI may block creativity by creating originality that is not an originality because it is a self-evident one. So academia often considers that human presence is essential. And except in the UK up to last week, the public authorities are more cautious on this. Basically, academia considers that the copyright, in order to obtain a copyright, there must be a human being. The UK has in its legislation clearly written that the human being should be the owner of a copyright, that there should be human presence in the copyright. Well, it is perhaps not true anymore. The US, under the precedent administration, went to the direction of the UK, which is quite rare. Normally, Europe follows the US and not the contrary. In this case, the US went in the direction of Europe, but doesn't seem at all to go in the direction of Europe. When the British Prime Minister went to Washington, D.C. a week ago, he stated that they may be in data collecting for AI purposes against creating AI data centers in the UK. The UK may forgive the rights of UK copyright holders. So public authorities are more hesitant on the absolute necessary need for the human presence, the essentiality of the human presence. Also, clearly enough, the AI challenges, under its current model, the three-steps test in copyright. I cannot apply the three-steps test with AI, or I can hardly apply it. So the three-steps test of the Berne Convention doesn't work with AI, or not well. So this is the problem with copyright. With trademarks, we face problems that are identical to copyright. With trademarks, patents, design law in Europe, we face the same problem on novelty and originality. The objective of Europe, by Europe, I'm talking of the European Union, but also of the UK, Switzerland, Norway, and other countries, it is to promote AI, but avoiding all forms of appropriation by the machine. We have, some of you have studied, know that we have a German gentleman called Stefan Thaler with a PhD and who prompted an artificial intelligence called Dabus to create an invention. This gentleman traveled electronically the world, and he requested that Dabus could be the author and could be the inventor of some outputs. The European Patent Office, of which the UK is member, European courts, the USPTO, the US Library of Congress, the Copyright Office of the US, refused this approach. And courts refused this approach. So up to now, in the OECD countries, a machine cannot be an author or an inventor. Yet, after a first movement in a certain direction, Australia opened a very small window and pulled back very rapidly. South Africa, which for other internal reasons is full of creativity in its legal approaches, South Africa gave some ground to the requests of Dabus. And this is the only country in the world up to now. Does this open a window to changes? Chinese legislation, which is up to date and of high quality, does not establish machine authorship or inventorship. So it does not though it does not totally close the door to it. We are at this very, very stage of our research. I wouldn't wish to keep this talk too long. I would wish to briefly mention what the European Union did. This is the neighbor of the UK. And as such, the European Union was full of good intention good intentions, or what it thought were good intentions, by adopting what is called the Artificial Intelligence Act. I actually don't know what it is because the EU does not edict any acts. Acts are edicted, for example, by the US, but not by the EU. It's a nickname. It's simply a regulation, an EU regulation. The text, which is directly enforceable in the 27 EU states, was adopted in a very, very quick process, in a very fast process. And this was connected to political needs. The EU commissioner who was in charge of the project wanted that it be adopted before the June 2024 elections at the European Parliament, so that it be not delayed further, so that this would be a good point for his re-election as commissioner or for his promotion. The only problem is that the text was adopted, but he was sent away. So the text was adopted very, very rapidly. And this is quite an issue. It contains implied obligation to mitigate the risk of IP infringement, but it leaves to the Court of Justice much of the interpretation of these obligations. And it is very, very light on IP. It is light on IP because US companies, the same GAFA, were not so favorable that there be too many strict rules on it. And the commissioner wanted to finish quickly the discussions so that the text entered into force. So debates were a bit stifled so that the text be voted on time before the end of the previous legislature. So the text was widely adopted, but this is all but a masterpiece of law. It has simply only 14 declared short circuits with non-repealed other EU legislation on IP. So the text is not much of use for us IP lawyers, but is of use for us lawyers, in particular for IP lawyers, because we need to wait until the Court of Justice sorts out all the discovered short circuits in the text. So I won't detail much because I think I'm over my time, but you will have all these slides. The incomplete work on IP, the AI Act does not contain express obligations for deployers, does not contain clear provisions on data governance, and not much reference to third-party IP for transparency. So whereas it tries to limit abusive use of AI in many other fields, such as civil liberties and so on, it does not perform its job for IP. In conclusion, the European Union sounds to be a model environment because it has the legislation everybody would dream to have in this little world. However, is the legislation premature? This is a big problem. Law always follows tech. When should we create legislation? If it's done very quickly, the risk is that it be premature and it stifles innovation. The European Union has a beautiful tradition on this. It adopted in the late 1990s, with strong UK involvement for this, the directive on patenting of biotechnology. And the result is that the the biotech industry of Europe mostly moved to New Jersey, to the US, which certainly is not a success for the directive. So on another hand, on many other fields, the EU has established legislation quite soon and very usefully, as long as the market can be shaped in a sense that is suitable for business and society. The US, the previous administration, not talking of the current one who exactly follows with big multiplicator what the previous administration has done, the former US president has simply issued an executive order declaring that, yes, the US should develop legislation on these topics at a certain stage. And nothing else was done. The current president follows this way. So how will the European Court of Justice react to the incomplete provisions and to the short circuits of the AI Act? This is a big question mark. So we have currently in this little world one example of legislation that partly covers IP and replies to AI, to IP concerns in AI, but in a very limited way. This is the model, this is the counter model, this is the no model, question mark. And this is where we stand as legal scholars with this very issue. With this very issue, bearing in mind that Europe is in the forefront of legislation, but only in legislation, in technology, due to abandoning industrial policies as of the 1980s. The European Union and the non-EU member states of the European continent, of the EPO, find themselves in a very, very difficult situation to handle the substantive issue on creating AI, and therefore in the very difficult situation to handle the legal issues that come out of AI. Dear and esteemed colleagues, dear and esteemed senior students, this is all what I would wish to present at this very stage, but I'm next to you to reply to questions and to build discussions out of this short presentation. Thank you.